Okay, welcome to tutorial number 3 in my series. This is for clients and other people. This is what is a suspended sentence. I've titled this one Much Better Than Prison, and you will find out why in just a little bit. If you want to find all my tutorials, go to eltonjenkinslaw.com and check out the blog page. You can also go over to my YouTube channel, watch all the videos, and you can obviously subscribe. First, what is a suspended sentence? Much better than prison. Obviously, if you're doing prison time, you're inside the confines of a prison, usually in a jail, or that's up to a year. And if you're doing prison time, that's in the Department of Corrections here in Oklahoma. It could be for anything from a day all the way up to life. Definition of a suspended sentence is a sentence of prison time in which the judge orders that all of the time be suspended on the condition that the defendant complete the rules and conditions of probation, allowing the defendant to complete his incarceration outside of prison. Put down here referred to as paper time, or doing your prison time on paper. The reason people call this paper time is that you are doing your prison time and it is a conviction, but you have a second order that suspends it on the condition that you do your rules and conditions of probation. So that's why we say that you are doing prison time outside of prison. The suspended sentence pros and cons. The pros here, I have a defendant is allowed to complete part or all of his sentence outside the confines of a prison. Upon successful completion of rules and conditions, the sentence is discharged. It still results in a conviction, but you successfully discharge your time, so after you're done, there's nothing they can do about it. The amount of time that a defendant may spend incarcerated for probation violation is fixed, meaning, for example, if you get a 5-year suspended, you can never get more than 5 years once you are sentenced to a 5-year suspended, even if you're revoked in full. A little bit different than a deferred sentence. Number 4, the defendant does not have to risk a longer sentence that might have resulted from a blind plea or a trial. For example, if something carries 10 years and you get a 5-year suspended, 5 years is the most you can do. Even if you have a deferred sentence, if you're violated on that, you could be sentenced up to 10 years. The cons here is a suspended sentence results in a conviction for the defendant. That's probably better than going to prison, but it does not keep you from being a convicted felon. If the defendant violates probation, it's very likely the defendant will serve prison time. The reason for that is on a motion to revoke, which we'll talk about later. The only question is if you have violated your probation, and then if the prosecutor can prove it, how much time of that suspended sentence is going to be revoked, which necessarily means prison time. A suspended sentence is not allowed without a waiver of the prosecutor if the defendant has 2 or more prior convictions. This is very important because if somebody comes to me and they already have a couple of convictions, it's barred by law unless the DA signs off. And so for me, that turns my audience from the judge or jury necessarily to maybe the prosecutor, and we'd have to convince them to have a good reason to do something about it where you can still get a suspended sentence. Most of the time that involves doing a program, or maybe making sure they believe that there is that's not necessarily going to get a conviction out of you, or they might lose at a trial. The defendant may not change the terms of his or her rules and conditions once the defendant has been sentenced. Once that is done, it is set in stone. Extremely important. I hear this all the time from my clients. I can't do this. I don't want to do this, or this isn't fair. Well, once it's signed by the judge, it is a done deal, and it takes a lot of effort and a lot of time to change that if you can. The last one is may not be expunged without a pardon, and we'll talk about pardons in a different tutorial, but it is very difficult. So if you get a suspended sentence, count on not getting it expunged. This is a typical timeline for a 5-year suspended. I just picked this out. There's nothing special about a 5-year suspended, but do understand that the amount of time that you could get suspended has to be within the range of punishment. For example, possession of CDS is 2 to 10. So if you get a suspended, it has to be at least 2 years and not more than 10. If you don't have any prior convictions, that gets a little complicated. We'll do that in a different tutorial. So on a 5-year suspended, today you would go in front of the judge and you would waive a jury trial. That's part of the plea bargaining. They're giving up their rights to try to put you in prison, and you're giving up your rights to go and make them have to prove your guilt at a trial. The defendant enters a plea. It's either guilty or no contest. There's one other one that's a little complicated, but it's not for now. Judge sentences the defendant to prison time, so there's one order that sentences you to prison time. Let's say it's 5 years, and then the judge does a second order that suspends that all or in part. In this example, we're doing it in full, and so it's the time that you have to actually do is suspended, but the judge is going to order you to do rules and conditions of probation. This is the deal you are entering into. You have to follow them to not go to prison, and if the DA can prove that you didn't follow them, then you're looking at getting some time revoked, maybe all the time revoked. I'll put a little timeline with the arrow going this way. So during your sentence, you're going to pay all your fines and costs. You're going to provide proof of that you've completed all the requirements that the judge put on you. Treatment, drug and alcohol evaluation, community service, things like that. The defendant commits no new crimes. Every rules and conditions is going to be contingent on you committing no new crimes and them not being able to prove it. The defendant has to test negative on all drug tests. It's going to be mostly for supervision. Sometimes you can get away with not having that if it's unsupervised, but that's all negotiable. If all special roles are completed, the defendant is released from supervision after 1 or 2 years. 2 years is usually the longest. It's typical 1 or 2 years, but that's negotiable too. And then at the end, 5 years from today, the defendant successfully discharges his sentence. Let's say you get all this stuff done. You paid all your fines and costs. We call that living it out, and you basically have served your 5 years in DOC, but you got to do it outside of DOC. That's Department of Corrections, by the way. The court loses jurisdiction. The defendant cannot be punished for a violation. So if you go 5 years and 1 day and you get a DUI, well, it is a new violation, but it is not during your probation. And then another question I have is, well, I got a DUI before I took my fine suspended, but I haven't been found guilty on it or taken a deal on it yet. Is that a violation? No. From the day that the judge takes your plea to the day you discharge, an act of a crime has to take place during here for it to be a violation, not being found guilty of one, but the act itself. The defendant may apply for a pardon from the governor, and if you are successful here, there's another expungement statute that allows you to get that expunged if the judge or the governor allows it. This is if you are unsuccessful. A lot of this is the same. You're going to waive trial, enter a plea, sentence you to prison time, suspend it, and order the rules and conditions of probation be followed. Now the difference is let's say you violate it. The defendant violates rules of probation by, I'll just pick some examples, not providing proof of all requirements. That's the community service, evaluation, stuff like that. You may have been accused of a new crime. Notice I said accused, not convicted or committing one. Test positive on a drug test, for example. The prosecutor would file a motion to revoke a suspended sentence. Remember that the prosecutor can't do anything. They ask the court to do it, and it's the judge that would revoke some of your sentence if that were to happen. You get arraigned on that, which means you're explained what they're accusing you of, and then the law says you get to have that hearing within 20 days unless you waive it. Often we waive this, and it's for strategic reasons on our part and on the DA's part, because a lot of times we need to see where the chips are going to fall. If the allegations are proven, let's say you go to hearing or you admit to the judge that you violate your rules and conditions of probation, then the judge is going to decide a few things. Typically, what's supposed to happen is how much of your suspended sentence is revoked. Of course, you can set off sentencing and see. We'll talk about that later, but typically, if the DA is successful, that's how it works. And then if the allegations are not proven, well, then the motion to revoke fails. The judge does not sustain it, and then you just return back to your suspended sentence. Other solutions I put here, if an agreement, enter agreement to withdraw the motion if conditions are met. For example, you didn't do all your community service. Well, you might just buy some time to get all of it done, because it's hard to put somebody in prison for just not getting all their stuff done. But push this too far and don't get it done quick enough and leave them no other choice but to put you in prison, well, that's what ends up happening sometimes. You can challenge the allegation. The burden is preponderance. Notice that this is not beyond a reasonable doubt. What this is the DA has to prove with some kind of credible evidence that it's more likely that you violated your probation than it is unlikely. So we're talking 51% here, and some of the rules of evidence are relaxed, hearsay, things like that. So it's much easier for them to beat you by proving that you violated your probation and getting a new crime than it is to prove the new crime itself. You can also run the time to do with the new case. For instance, you catch a new felony and then they want 5 years out of you, and you might get 5 years out of this one, and you don't want it to run consecutively, which is 5 plus 5. Sometimes you can enter into an agreement to just go ahead and have those run together, saving you 5 years in DOC. Or you can serve a sanction. This is sometimes weekends, sometimes doing extra things. Weekends are typical, maybe putting you on a clean start program where you're tested all of the time, or much more often. RTP sanction, that's a 6-month program that's in DOC. That's for people who that's usually only a good deal if you're looking at being revoked for a lot of time, but it's there for us to use. Who cannot get us suspended? This is extremely important. These are the handcuffs that some defense attorneys, or that we have under the law. Defendant has 2 or more prior felony convictions. You are barred by law, and that means the judge, if the DA can prove that you violated your probation, then we cannot argue that you can get a suspended sentence on a blind plea, because the legislature has said that you can't, so you can't. So you have to get some other things done we'll talk about in a second. Prior convictions may be used for enhancement up to 1 year after the completion of a sentence. I'm sorry, that says 1 year. It's actually 10 years after the completion of a sentence. For example, I'm sorry, this is 10 years. If you get a 5-year suspended sentence, you live out that 5-year suspended sentence, it's another 10 years that they can use this on your second page if you get a new crime, and those are going to be the prior convictions we're talking about. So this kind of contemplates that you have a new crime in the future. Hopefully you don't, but if you do, they get to use a conviction for 10 years after the completion of the sentence. So 5 years suspended equals 15 years. They can use it against you. If you're found guilty at a trial, you can count on a judge not going against a jury. If they give you 5 years, then you're going to get 5 years. They rarely are going to suspend it. That's partly political. It's partly because you asked for a trial and you were going to get a not guilty. You get to walk out, then you have to live with what you get, basically. And I hear judges say that after trials. Sometimes that's, if you want a jury trial, you get to walk out if you win, and you get to go to prison if the jury says you should go to prison. Next one, when the facts of the case will cause no judge or prosecutor to allow it. For example, these are kind of obvious. A lot of judges, if you got an alleged child as a victim, they're not going to give you a suspended sentence. Probably not. Violent crimes, if this is on like older people or children, or if you have an extensive record, they just aren't willing to give you a suspended sentence, partly because if you commit a new crime, then egg's going to be on their face. Getting a suspended sentence anyway, this is going to be the waiver that we're talking about if you've got 2 or more prior felony convictions, or they can dismiss the second page allegations, which means even though you have the convictions, they can drop them from the allegations, and so they can't be used against you. How are we going to do this? Cases in which the prosecutor is likely to lose. This is where your attorney comes in. This is why when you come and talk to me, I'm always asking about who are our other witnesses. What are your defenses? What evidence do they have against you? Because the more that I can show the DA that it's likely that they're going to lose, the more likely they're going to want to just take what they can get. Cases in which the alleged victim convinces the prosecutor to waive. These are going to be your domestic abuse cases where somebody gets the attention they need or takes a class. Maybe the family needs to not be broken up. Maybe it wasn't that bad. And then you've got a sympathetic alleged victim going over there and talking to the DA and asking them to do it. Willing to agree to an alternative court program. This is going to be your DUI courts, your community sentencing, animate bride. That's going to be people with mental health issues. Military courts getting a little more popular. So if we can find a way for you to get in here, sometimes you can get us suspended anyway. Problem with that is that if you have any kind of violence, or if you have a conviction for being a drug dealer, for example, you're not going to get you're not going to get drug court, for example. They don't want those people in there for liability reasons. If it's a white collar crime, if you can pay all your restitution up front, I hate to make it sound like you're buying a suspended sentence here, but if you can pay all your restitution up front, or if you can convince them that a suspended sentence is going to get that restitution paid, remember that prosecutors are people too, and that their concern is going to be with alleged victims getting their money back. So sometimes that's a bargaining tool. All rules and conditions have been completed before plea. This proves to a judge and to a prosecutor that you are worth having taking a chance on, and prosecutors are people too. If you put the work and effort into it and you've earned it, sometimes they'll take that into consideration and agree to do a waiver or dismiss a second page and give you that chance. Or witnesses cannot or will not testify. That gets very complicated, but witnesses have their reasons, and if that's kind of dovetails with this one up here, if they're likely to lose. Obviously, they need witnesses to prove their case, so if they don't want to testify, or they can't find them, or for whatever reason, it's going to make it likely they're going to lose, and they're going to want to just take what they can get. Okay, that is a suspended sentence in a nutshell. And remember, best place to find this is going to be on my blog, and you can go through here and click on the YouTube hypertext link here, or you can go straight to the YouTube page. You can subscribe, or you can just watch the videos. Okay, and then on this website, if you have any questions, you can obviously go to the website, click this learn your rights, and then as long as you do not have an attorney already, which I can't talk to you if you already have one, but if you don't have an attorney already and you have a question, you can always send me something here, and then you can always call my office here, and also at 579-1678, area code 405. All right. Stay tuned for my next tutorial. Should be something good, and you can also ask for requests, and I'll try to answer them.